Welcome to the CCK Law Q&A segment. These questions have been inspired by our viewers. We've heard from clients, we've heard from commenters and other practitioners. And so remember that all of these answers are just informational. This is not legal advice, but we wanted to take a time to answer some questions that those of you have had. And if you have a question that you want answered, make sure you drop it below in the comments and we'll see if we can get to it in our next segment. So Mike, why don't you start us off with some questions we've gotten from viewers?
So I'm going to read this question here. It says, what about people who go from TDIU to a 100% P&T permanent and total scheduler rating? If your VA benefits letter lists you as both 100% permanent and total and TDIU, meaning unemployable, are you still not allowed to work, even though you're now 100% permanent and total scheduler? So I'll say, at first, I think it's important to recognize that they are two separate things.
Correct.
TDIU is a benefit awarded when a veteran's service-connected disabilities in totality prevent the veteran from being able to obtain and maintain what VA calls substantially gainful employment.
Right.
A veteran does not have to have any particular combined disability rating to get that benefit, right? I mean, it's helpful the higher the combined rating is, and there's specific regulations that state, if a veteran is combined at 70% in total, there are certain avenues that make it easier to get that benefit, generally speaking. But it's a separate benefit from when a veteran has a number of different or perhaps one, but a service-connected or service-connected conditions that collectively, using VA's mathematical formula, add up to a 100% scheduler rating. So they're separate things. So to answer this specific question, I would say, and they say, are you still not allowed to work even though you're now 100% permanent and total scheduler? As a general rule, I would say, correct me if you think I'm off here, but as a general rule, a veteran with TDIU typically can't work and receive the benefit. There are exceptions for certain. We may talk about more of those later, but generally, a veteran who is receiving TDIU has been given that benefit because it's been deemed that they're unemployable.
Mm-hmm.
So if a veteran returns to work or is working, there's a significant likelihood that that benefit could be reduced or taken away. The other hand is a veteran who has a 100% combined disability rating. They may have that through a number of 10% and 20% and 30% individual ratings.
Right.
Sometimes you see a code sheet which lists all the veterans' conditions that have been service-connected, and it could run a couple pages long in some instances. In that situation, the 100% combined rating is awarded to recognize all of those individual disabilities and not necessarily awarded to say that the veteran is unemployable. So
Right.
A veteran who has a 100% combined disability rating, permanent and total, could in theory still work and still receive the 100% permanent and total disability rating.
Right. And so I just caution whoever asked this question, make sure you actually have the Scheduler 100, that you see in documents from VA, your combined rating is 100%, because you get paid the same amount at 100% and TDIU. And that's why I think veterans get confused. They're getting, was it $39.97 a month with no dependents? And so they think that they have 100%, but in fact, they're getting TDIU. So find out what your combined rating is. If it's 100, you should be free to work. If you're getting TDIU and you're not 100%, I would caution you against working. Also, beware that permanent and total rating. I think a lot of our clients, a lot of veterans who contact us seeing if we can help them get that stamped onto their rating decision. And the issue is that it's not actually permanent, right? It's permanent in the sense that VA is not going to bother you. They're going to leave you alone. But if you start filing more things, they have the right to start poking around and potentially reduce you. So permanent in total, I know, has a lot of benefits outside of the VA space. There might be state-specific benefits that veterans are looking for with that P&T status. But for this question, just take a close look at what you're actually rated for.
Yeah, it's a great point. And one final thought for this question, how a veteran has achieved the 100% P&T rating matters too.
Mm-hmm.
So I've seen cases where a veteran is rated 100% P&T for one service-connected condition, and that service-connected condition is, say, PTSD. Now, the way that the mental health ratings work is that a 100% rating for something like PTSD is typically only awarded when VA finds that the veteran is totally occupationally impaired.
Right.
So you can see the kind of the natural contrast there with a veteran who is, got a grant of PTSD for 100% on the basis that they're totally occupationally impaired and trying to work. The fact that they're trying to work or working can conflict in some ways with the fact that they've been granted with 100% permanent total for PTSD. So the type of condition the veteran is awarded the 100% rating for does matter. So every situation's different and unique, but I think generally speaking, that's the difference between the two.
All right, let's take a look at another TDIU question. I have heard that in order for benefits to be reduced, a TDIU veteran would have to be found to have worked 12 consecutive months and earned wages above the poverty threshold. Does that mean if, for example, the veteran has earned more than the poverty threshold but hasn't worked 12 consecutive months, in that situation, VA wouldn't have grounds to terminate TDIU for that veteran? Again, a very specific fact-specific question, but let's talk as general as we can. So the poverty threshold speaks to a component of TDIU, which is substantially gainful employment. So TDIU is awarded for veterans who can't secure and follow, obtain, and maintain something called substantially gainful employment. If you are earning below the poverty threshold for one individual person, despite the size of your family, even if you have a spouse and 3 children, it is the poverty threshold for one, then VA does not consider that to be substantially gainful employment. Those earnings, I think it's around $12,000, I want to say. Maybe it's a little bit higher, 13?
Slightly higher now, yeah. It's 13,
it goes up
14.
With the cost of living index with Social Security, but let's say it's about $13,000. If you're earning under that, it is unlikely, not by choice, but by virtue of the limitations of your service-connected disabilities.
Exactly, yep.
VA will likely not find that to be substantially gainful. If you earn more than that, and no matter how long it took you to earn that, that's substantially gainful employment. It doesn't matter if it's a month or 12 months or 6 months. It's substantially gainful earnings. So in that respect, you might no longer qualify for TDIU. The 12-month component, I think, comes into play because VA will look yearly, and they'll get a report from Social Security to see if you have any disability tax earnings, your Social Security wages for that year. And so if they report back that you made $30,000 that year, VA may very well kick you off TDIU. It is fact specific though, and I think it gets tricky for our potential clients and clients who have maybe gig work, driving for Uber.
It's a big one nowadays.
Yeah, driving for DoorDash,
all the time. Yep.
Substitute teaching.
Substitute teaching is another big one.
Yeah, it can be tricky because the question VA has, not us, the question VA has is, okay, could you earn more if you worked more? Like, are you doing this gig job because your disabilities prevent you from showing up to a job, or are you doing it by choice because you want the flexibility of working when you want to work? We really see that with substitute teaching. It can be a really big impediment for people who are trying to get TDIU, but also substitute teach because the nature of substitute teaching is limited. Bus monitor, crosswalk monitor, those types of things. So to this person who asked the question, VA will look. In my experience, they aren't going to care that you earned it in 3 months versus the whole year. If it's more than that poverty threshold, you've earned substantially gainful employment.
Yeah, no, those are great points. That the reason why the veteran cannot work really matters here. And so to your point about the substitute teacher, that was an example I was thinking of as well. Yeah. We do see it frequently. The nature of the work is that the person typically works for less than 12 consecutive months in a year. So in order to prove one of those cases, you can use lay testimony, an affidavit. You can get tax documents. But at the end of the day, you really need to show that the limitations that come from your service-connected disabilities, and only we're only looking at service-connected disabilities here. that those limitations prevent you from working more.
Mhm.
VA will often make the mistake of saying, well, you've got this really bad back injury, right? That's not service connected. That's the reason why you can't work. And that's an error we see all the time. It doesn't matter, as severe as the non-service connected back injury may very well be. VA's analysis needs to be laser focused on the service connected disabilities and only those service connected disabilities.
Yeah.
And when looking at only those disabilities, they need to make the determination whether the veteran can work substantially gainful employment. So if you see them, and this happens often, like I said, and I know you see it all the time too, VA starts to wander and they start to pinpoint a bunch of non-service connected conditions and say that's the reason, you need to call them out on that.
Yeah. Right.
How hard is it to prove a nexus, which again is just the link between, an event in service, for example, and a diagnosis to prove service connection? Person said a VA doctor's allegiance seems like it would be really to VA, as is the CMP examiners. But low-income vets cannot afford an outside opinion from an independent doctor, and an outside doctor might not even understand what you want them to do.
This is such a good question.
It is.
Like my blood's already boiling for this question.
Well, I think at the outset, it's important to recognize that now CMP examiners are largely third-party contractors, right? So they're not technically VA employees. So take that. And
it shows.
And it, well, anyone who's received a CMP examination will see that that the quality is not as we might hope. But with that, I think, like we said, it's important to recognize that these are not VA employees.
Right.
So sure, perhaps the argument could still be made that their allegiance isn't with the veteran, but I also don't know that it's necessarily true that they are looking out for VA's best interests just inherently. I think my opinion is that a lot of the quality issues we see with the CMP exams have to do with just, the veteran going in and receiving a bad exam, or the examiner hasn't reviewed the record, or maybe there are, and I'm sure there are, some personal biases with the individual examiner.
Mm-hmm.
But I don't know that you can say that the CMP examiners writ large have an allegiance to VA over the veteran. Maybe you disagree, but I think it's more individual, and I think a lot of times it gets caught up in the bureaucracy that is the disconnect between a third-party contractor and the VA, and veterans going in and sometimes having difficulty because of their disabilities accurately reflecting what their disabilities truly are in terms of severity.
Yeah.
So there's a lot of that too.
And I think that what definitely comes through lately is, however, that independent contractor has structured their payment system with those examiners. So the allegiance might not be to VA, but the allegiance is to, how am I going to get compensated for this exam by the person I'm working for? So we've had a lot of complaints, and we've seen a number of exams that are clearly rushed, barely filled out, basically useless. Why even have the exam at that point? So, great question. Let's hit some other points of it, though, because I think it's got, 3 or 4 components here.
The second part of it, which is a great point, many of our veteran clients, unfortunately, come to us with little financial means.
Yeah.
They're in difficult positions, obviously, due to their disabilities and just life circumstances. So what does a low-income vet do who they know they need an outside medical opinion, but they can't afford one? Or even if they can afford one, they're skeptical that an outside provider would be able to fully comprehend the complexity that is VA law.
Yeah.
So with that, I think a couple things. Right off the bat, not in every situation, but oftentimes veterans can obtain a nexus letter from a treating physician. Not maybe going to be the most thorough opinion as if you were to contact an outside independent provider and pay a lot of money for it, but it can be sufficient. And oftentimes a treating physician will, provide that service and provide a letter that helps to connect a disability that they're treating for with their time in service. Outside of that, though, VA representatives or VA-accredited representatives and attorneys like ourselves, this is something we do every single day. And we know the right people to contact. Oftentimes, there is no cost to the veteran unless we're successful on that particular issue for which we obtain the opinion. And so, like I said, there's no upfront cost to the veteran at that time. And people like ourselves, we're able to help explain to an outside provider what issues need to be hit, what we need to focus on, what we shouldn't focus on, and then allow the independent Nexus provider to deliver an opinion on their own that is either up or down.
Yeah.
And then we can see what the merit of the case is at that point.
And so a couple other, things that this question raised for me. It used to be when I first started doing this that your VA treating provider, your actual treating doctor, some would write Nexus letters for their patients. I don't know if it's like a VHA policy or a directive, but I have heard that they have been instructed they're not allowed to do that because somehow it muddies the relationship between treating doctor and patient. So unlikely that your VA treating doctor will give you a Nexus opinion.
Yeah, yep.
However, if you treat anywhere else outside VA, whether that be a PCP or any type of specialist, you can ask them. We have a lot of content on Nexus letters. I hate to say, go do more research, but we have, whole videos and blog posts on what's needed in a Nexus letter, the standard, as likely as not. You need to make sure that provider has reviewed your entire medical record and maybe service record too, and that they're using the right standard, that magic language that VA wants to hear. Other than that, it's supposed to be non-adversarial. VA is supposed to be on your side. The VA examiner should not be trying to disprove, but look at this in a positive light and see how they can help you. And so if you experience any situations in which you're feeling like that's not happening or aggressively not happening, speak up, let VA know, complain, appeal. Don't just let it, continue because it should not be that way.
And that brings us back to the first point, which is because we see inaccuracies and issues with VA examiner opinions so frequently, it's critical that veterans, either on their own or with the help of an attorney or an accredited agent or, DAV or another organization, you got to be able to point those things out in an appeal. It's critical that you don't just let it go, that you highlight it, you address it. We have the ability to, use case law and our years of experience to be able to identify those flaws and issues in the exam and then make legal arguments that address it.
Yeah. Okay, last question for today. Can a veteran get disability for smoking-related conditions? What if smoking was used as a training incentive when a service member was in training? Okay, great question. And this is a callback. We did a segment on secondary conditions to mental health conditions. You cannot get service-connected for nicotine-dependent cigarette use in and of itself. However, if you started smoking in service because they were in your rations, and that happened, not anymore, but they did, and you continued to smoke because of something else, we talked about that. Maybe it's a mental health condition, maybe it's a pain condition, orthopedic condition, the smoking helps you relax, whatever the case may be. You can get service connected for any conditions that result from that nicotine and smoking dependence. For example, a cancer, diabetes, hypertension,
respiratory issues,
the
obviously,
whole litany list, laundry list of things that come from cigarette use and smoking. So I hear you. I hear that, you were handed the cigarettes along with your rations, and I appreciate the sentiment that, I was given this, I should get service connected for it. But unfortunately, that's not the law. It doesn't allow for that. But it can be a link between a service connected condition and a subsequent condition.
Yep. And aggravation here is key too. It's, the worsening of a smoking addiction due to PTSD or anxiety that ultimately a medical provider would have to provide this opinion, but that ultimately led to one of those secondary conditions that you talked about. That can provide the link as well, even if, you entered service perhaps smoking, 1 or 2 cigarettes a day, but you came out, 2 packs a day, just as an example.
Yeah, that's a great one.